This is the seventh part of the lecture on the topic of interpretation of section 6 of the Hindu Succession Act as amended by Amendment Act of 2005. In this part, we will consider the state amendments. Amendment of 2005 was made by the Union of India, that is central government, and this amendment is applicable to the whole of the India. However, much before this central amendment, the state of Andhra Pradesh in the year 1986, the state of Tamil Nadu in the year 1989, the state of Karnataka in the year 1994, and the state of Maharashtra in the year 1994 have already made amendments in the Hindu Succession Act for the purpose of conferring equal rights to the daughter of Coparcenary. However, those state amendments were restricted in application to that particular states only, and this was the reason for making amendment of 2005 by the Union of India central government, which is applicable to the whole of India. Thus, those state amendments the state of Andhra Pradesh has made state amendments which came into force from 5th September 1985. State of Tamil Nadu made state amendments which came into force from 25th March 1989, and the state of Maharashtra made state amendments which came into effect from 22 June 1994. If we consider the actual wording of the provisions of these state amendments of these three different states, we can find out that, we can notice that the wording of all these state amendments, all these three states, Andhra Pradesh, Maharashtra and Tamil Nadu, wording of the provision, amending the provisions is same, are same provisions, same wordings. So we will read the provisions of Maharashtra amendment. So for the purpose of amending earlier section 6 in the Hindu Succession Act of 1956, the state of Maharashtra has inserted one new chapter, that is chapter 2A, capital A, 2A, thereby inserting three new sections in that chapter, sections 29A, capital A, 29B, capital B, and 29C in this Act of 1956. The heading of the section 29A as amended by the state amendment, the heading is equal rights to daughter in coparcenary property. So the wording of this state amended section 29A of the Maharashtra amendment, it is the same wording also in the section 29A of the amendment made in Andhra Pradesh and amendment made in Tamil Nadu. Same wording there also in section 29A. So section 29A it says as, notwithstanding anything contained in the section 6 of this act, clause 1, in the joint Hindu family governed by the Mittakshara law, the daughter of a co-parsoner shall, by birth, become a co-parsoner in her own right in the same manner as the son. Section 29A is having overriding effect over the earlier section 6 of the Central Act of 1956. Therefore, it is said, notwithstanding anything contained in section 6, that is earlier section 6 of the Central Act. So, notwithstanding anything contained in section 6 of this act, in a joint Hindu family, the daughter of a co-parsoner shall, by birth, become a co-parsoner in her own right in the same manner as the son, and a daughter of a co-parsoner shall have the same rights in the co-parsonal property as she would have had if she had been a son. This is a clause 1 of section 29A, state amendment. Then clause 2, at a partition in such a joint Hindu family, the co-parsonal property shall be so divided as to allot to a daughter the same share as is allotable to the son. So in case of partition, daughter will get same share to that of son. Then clause 4 is more important of the section 29A state amendment. Nothing in this chapter 2A shall apply to a daughter who is married before the date of commencement of the Hindu Succession Maharashtra Amendment Act 1994, that is before 22nd June 1994. Means daughter who are married before the date of commencement of State Amendment Act, that is before the 22nd June 1994, who are married before 22nd June 1994, they will not get the status and right of a co-parsoner. And clause 5 of the section 29A says, nothing in clause 2 shall apply to a partition which has been effected before the date of commencement of the Hindu Succession Maharashtra Amendment Act 1994. So we have seen the clause 2 which says that in case of partition, daughter shall get equal share to that of son, but this clause 5 says nothing in clause 2 shall apply to a partition which has been effected before the 22nd June 1994. Now, on this aspect, I didn't found any case law of the Bombay High Court or of the Supreme Court on the Maharashtra State Amended provision. But I found one important case law on the Andhra Pradesh State Amendment, a case law of the Supreme Court, which recognizes the status and right of daughter of co-parsoner as per the State Amendment. As I said earlier, wordings of the State Amendment Section 29A in Andhra Pradesh and also in Maharashtra, it is one and same. So I found one case law of the Honorable Supreme Court, judgment of the Honorable Supreme Court in the case of S. Sai Reddy versus Narayan Reddy and others. This case is reported in the Supreme Court cases year 1991 volume 3, page 647. So, in that case, relating to section 29A of State Amendment of the Andhra Pradesh, the facts of the case was that the appellant S. Sai Reddy has filed a suit in the trial court against appellant S. Sai Reddy filed a suit against his father and brother for partition of the ancestral joint family property, claiming 1/3 share in it. So S. Sai Reddy is the son. He filed a suit for partition against his father and one brother for partition of ancestral joint family property. The trial court decreed the trial court passed the preliminary decree. The trial court passed the preliminary decree declaring that appellant's son as well as his father and his brother each were entitled to 1/3 share in the property. Therefore, the defendants preferred appeal before the High Court against said preliminary decree. Defendant father and brother filed appeal before the High Court against the preliminary decree. That appellant S. Sai Reddy was also having 3 unmarried sisters. Therefore, the High Court confirmed the finding of the trial court in the trial court with the direction that appropriate provision should be made for the maintenance and marriage expenses of respondent number 2 to 5 who were unmarried daughters of the appellant. So, High Court confirmed the finding of the trial court granting 1/3 share to the son, but High Court gave a direction to the appellant as well as his father and his brother that they should make a provision for maintenance and marriage expenses of 3 unmarried sisters of the appellant. However, during the pendency of the proceeding before the trial court and prior to passing of final decree, the Hindu Succession Amendment Act, State Amendment Act, was amended by the state legislatures of the Andhra Pradesh, as a result of which unmarried daughters became entitled to share in the joint family property. So, in this case, after passing the preliminary decree, but before passing of final decree, Andhra Pradesh State Amendment came into force, and therefore those 3 unmarried daughters filed one application before the trial court claiming their share in the property in capacity of co-parceners, because they become now co-parcener by virtue of the state amendment. But the trial court rejected their application filed by those 3 sisters, that is 3 daughters. The trial court rejected their application on the ground that since the preliminary decree had already been passed and specific shares of parties had been declared, now it was not open to the unmarried daughters to claim share in the property by virtue of the amended provisions of the Act. So, trial court rejected the application of those sister or daughters. Therefore, those unmarried daughters preferred revision application against the order of trial court before the High Court of the Andhra Pradesh. The High Court, by its judgment, allowed the revision petition preferred by those unmarried daughters. The High Court allowed the revision petition and set aside the order of the trial court, thereby declaring that in view of the newly amended section 29A of the Act, the daughters were entitled to share in the joint family property. So, High Court has granted rights to those three unmarried daughters or sisters. Therefore, the appellant, that is S.I. Reddy, who is the brother of those three sisters, had challenged the order of the High Court of Andhra Pradesh before the Supreme Court, and thus this matter came before the Supreme Court. That is S.I. Reddy versus N. Narayan Reddy and others, reported in reported in Supreme Court cases year 1991. So Supreme Court ultimately held that, in this case, Honorable Supreme Court held that, observed that High Court of Andhra Pradesh has rightly held that since the final decree had not been passed and the property had not been divided by midst and bounds, clause 4 to section 29A was not attracted in the present case. Clause 4 of that state amended section 29A, what it says? Nothing in clause 2 regarding partition. Clause 2 is regarding partition. Nothing in clause 2 shall apply to a daughter married prior to or married to the partition, prior to partition, which had been effected before the commencement of the Hindu Succession Andhra Pradesh Amendment Act 1986. So the Supreme Court observed that the High Court has rightly held that since the final decree had not been passed and the property had not been divided by midst and bounds, clause 4 to section 29A was not attracted in the present case, and the respondent daughters were entitled to their share in the family property. And therefore, Supreme Court dismissed the appeal filed by their son S.I. Reddy in the Supreme Court. Thus, in this case, it was observed by the Supreme Court that unless and until the final decree is passed and the allottees of the shares are put in actual possession of respective property, the partition is not complete. A preliminary decree does not bring about final partition. Pending the final decree, the shares themselves are liable to be varied on account of the intervening events, and the preliminary decree does not bring about any irreversible situation. Therefore, unless a partition of the property is effected by midst and bounds, the daughters cannot be deprived of the benefits conferred by the amended Act. So, by virtue of the state amended provisions, daughters have got coparcenary status and rights. As far as the Maharashtra state amendment is concerned, it came into force with effect from 22nd June 1994. Accordingly, in the Maharashtra, had there been actual partition took place between 22nd June 1994 to 20th December 2004, and which was valid as per the prevailing law, then any such daughter of co-partner who did not got status of co-partner because of her marriage before 22nd June 1994, she was not entitled to any share in such partition. December 20th 2004, this date is referred in the centrally amended, newly substituted section 6. What it says? The partition which has been effected before the 20th December 2004 shall not become invalid, or it shall not be affected by the amendment. So as far as Maharashtra state is concerned, Maharashtra state amendment came into force on 22nd June 1994. So from 22nd June 1994 to up to 20 December 2004, if there had been any partition of coparcenary property of any joint Hindu family in the Maharashtra, in that partition, any such daughter in such joint Hindu family who because of her marriage prior to 22nd June 1994, who because of her marriage did not get any status or right of co-partner, such daughter shall not be entitled to any share as a co-partner in such a partition. However, if no such partition took place between 22nd June 1994 up to 20th December 2004, meaning thereby on 20th December 2004, the coparcenary and the coparcenary property is still in existence on or after the 20th December 2004, if there is a partition, then any such daughter who was otherwise disentitled because of her marriage before the 22nd June 1994 is now still entitled as being a co-partner to claim share in such partition by virtue of the Central Amendment Act of 2005. Means any such daughter who was otherwise not entitled because of her marriage which took place before 22nd June 1994, any such daughter is now, by virtue of the Central Amendment Act of 2005, now she is entitled to claim a partition as a co-partner, provided there was not already partition in that co-partner in that family, and co-partner property is still in existence. So in the Central Amendment of 2005, the status and right of any daughter as a co-partner, it does not depend upon her marriage, whether she is married or unmarried, or when her marriage took place. It doesn't depend upon that. So in conclusion, any such daughter in the Maharashtra who otherwise become disentitled to claim partition by virtue of the state amendment, she is very well entitled to claim partition now by virtue of the Central Amendment which came into force from the year 2005, provided that there had not been any actual partition in their family before the Central Amendment of 2005, and co-partnership is still in existence. It is also to be noted that in the Maharashtra, any such daughter whose status was unmarried daughter on the 22nd June 1994, or any such daughter who marries after said date, was entitled by virtue of the state amendment to claim direct share in the partition of co-partnership property belonging to her father's family, provided that there had not been actual partition till the date of her claim. So before coming into force of the Central Amendment of 2005, in the state of Maharashtra, in case of any such daughter 22nd June 1994. Such unmarried daughter has got a status and right of co-parcener. So she was, as per the state amendment, very well entitled to claim partition even before the central amendment came into force. So in this part we have considered the aspect of state amendments conferring rights and status of co-parceners upon the daughter.